Now, another exemption which is in a succeeding section after section 48, which enshrines the patent rights, talks about exceptions on patents which are used in foreign vessels. I am talking about section 49. Section 49 states that if any patented invention is used on a foreign vessel or an aircraft which is temporarily or accidentally in India or in the Indian territorial waters or in the Indian airspace, shall not amount to infringement, and no action of infringement shall lie against the owner of that particular vessel or aircraft. Which means that if there is an aircraft which has any kind of product which is on the aircraft, which is fixed on the aircraft, and it is landed in India and it's on the Indian airport, and they have not taken permission from the patent owner who owns the right in India, it will not be considered to be an infringement because it is there temporarily and it is there accidentally. The same logic applies to vessels, that is ships, boats which are there on the Indian territorial waters. This also means, very briefly to talk about registration, because by way of evidence the courts would want to look where was that vessel registered. If that vessel has been registered abroad, all is clear. If that particular vessel or vehicle or aircraft has been registered in India, then the question is, where is this use? Where is it going to be used? If it is ordinarily used in a place outside of India and it is only accidentally in India or the Indian territorial waters or in the Indian airspace, it shall not amount to infringement. Now we shall come to the very important Bular exemption, the one which is normally confused with the research exemption. The Bular exemption is a term which comes from one of the US case laws, Roche versus Bular. The whole idea behind this case, or the reason why this case was filed, is the inequitable time extension which has been given to a patent owner beyond the term of the patent. Now let me explain this very briefly. In many areas of technology, that particular patented product cannot be marketed unless it receives regulatory approvals for marketing from a regulatory authority. One very good example of this is drugs, medicines, medical devices, and even insecticides and fertilizers. They are required to be approved by the regulatory authority. In case of drugs, it would be the regulatory authority under the Drugs and Cosmetics Act. In case of insecticides, it is by the registrar who would then give the approval. That means even if the patent has been granted on the invention, it cannot be commercialized unless it has received approval from the regulatory authority. Now, this dual process means that the protection on paper is from the date on which the patent application was filed, but the protection in the market would be from the date where it has been granted. You are aware that under the prevailing Patent Act, the day the patent is granted, it is deemed to have, you have the rights from the date it has been published. That is the 18-month publication. Now, in this scenario, a third party who is waiting for this patent to expire, that means the patent rights to expire, and he is waiting to bring in equivalent products into the market, which we often call generics, but other non-patented products into the market. He cannot do anything about it till after the patent has expired, because if he has to manufacture it for purposes of submitting data for regulatory approval, he cannot do so because that may be deemed to be an infringement. He cannot take refuge under experimental exemption or research exemption because it is not research. What he is doing is he is manufacturing that particular product for purposes of submitting data to regulatory approval, for regulatory approval to the regulatory authority, so that he can get the marketing approval for commercializing. Therefore, whatever work that he does during the term of the patent would be deemed to be for purposes of commercialization. In such a situation, it would be very inequitable that when the patent term expires after 20 years, the patent owner continues to have an extended period of exclusivity, because it is only after the patent has expired can a third party work that particular patent, prepare his own equivalent drugs or medicines or pharmaceuticals, submit it for regulatory approval. And this enjoyment of this extra time is something which is inequitable, like I said earlier. And this was the main crux of the Roche versus Bollard case. While Bollard lost this case, eventually, there was a bill which was passed, the Hatch-Waxman bill, and this was approved by the US Congress, and finally it came into law, which said that there would be an exemption if the person is working any kind of patent for purposes of submitting for regulatory approval. The same thing has been enshrined in the Patent Act of 1970 by the Indian government, where we very clearly say that, if I may just read, this is section 107A. Any act of making, constructing, using, selling or importing a patented invention solely for uses reasonably related to the development and submission of information required under any law for the time being in force in India or in a country other than India that regulates the manufacture, construction, use, sale or import of any product does not amount to an infringement of patent right of the patent owner. This is really interesting. This is interesting also from the point of what is known as para 6 of the Doha Declaration. Many of you may be aware, and I am digressing a bit from this point, but the significance of section 107A, subsection A, is very clear, and it is a very progressive section and is extremely significant. Many of you are aware that in 2001, there was the WTO round of discussions, and in which they adopted para 6 of the Doha Declaration, which says that if there is an emergency or extreme urgency in a country and they declare it to be so, or if that particular country does not have a patent regime and they require a set of medicines, then any other country where there is a patent regime and a patent in force on that required medicine can export that medicine to this particular country which requires it, and it shall not be seen as an infringement. Now, this is, as you are aware, as part of a declaration, and there are many countries which are members of the WTO, were part of this, and to be able to enforce it by way of law, it has to be statutorily ingrained, or it has to be enshrined in the law. And that has been enshrined in our law under section 92A. Now, when a person under section 92A wishes to market, that is export a medicine to another country which requires it, then in such a case there are two things that needs to be taken into account. The first, the country which requires it must have declared that there is a requirement for that particular drug. And second, if there is a patent on such a drug in India, then the person who wants and person here also means a company, can go to the Controller General and he can declare that he would like to market this, and he files, he goes and he can prepare this and he can sell it or export it out of the country without any fear of a suit of infringement filed against him by the patent owner. Indeed, if a suit for infringement has been filed, he can approach the court with this evidence, and that itself will be a defense, a very valid defense against infringement. Now, in such a situation, for a person to export, and remember section 92A is only limited to drugs and pharmaceuticals, it is not for any other patented product. So, for a person to be able to export it to another country during the term of the patent, or for a person to approach the regulatory authority for purposes of marketing approval, he requires that data. He can prepare this under section 107 subs A, that is section 107A subsection A, without any fear of infringement. So, therefore, this is an extremely very, very significant and very progressive piece of legislation which has been incorporated. This was done under the Patents Amendment Act of 2002, which came into force on 20th of May 2003. So, this provision provides a statutory right to manufacturer to use the patented invention to develop and submit information required for obtaining regulatory approvals anywhere in the world, including India, without the consent of the patentee. This is especially useful for generic drug manufacturers, manufacturers of pesticides, fertilizers, medical devices which require regulatory approvals for marketing the product.